Immigration Advisor at GSM Immigration, and I'm also a Level 3 RC Registered Advisor. Please subscribe to our YouTube channel and click on the bell icon so that you can continue to watch our extremely interesting videos about UK visa and immigration advice. Today's topic is very unusually something rather complicated. In our last video, if you happen to have watched it, we talked about FLR FP applications. This is a bit of Home Office gobbledygook. It doesn't mean anything particular. It means an application which is made within the rules, but in a different part or slant of the rules. People who don't meet all the qualifications, all the requirements for the immigration rules. Last time we discussed FLR FP application on the basis of a partner. And I did tell you that it was rather a difficult application. It might be refused. This time I'm going to discuss a different kind of application. I don't say it's easy, maybe, however, slightly less difficult. We're going to discuss an FLR FP application on the basis of a child in the UK with whom you, the applicant, who possibly may be in the UK illegally, you may be in the UK as an overstayer, but if you have a genuine parental relationship, these are the legal words, a genuine parental relationship with a child, you may not be a biological parent, but you have a parental relationship, you can possibly make an application, FLR FP, on the basis of your relationship with the child. Now, the rules are written in a funny way. I'd like to explain them to you just a bit. The child in the UK must be either a British citizen or a child who's lived in the UK for at least 7 years. That's all the rule says. It doesn't say anything more. It doesn't say that the child must have been born in the UK. It just says that they must have lived in the UK for 7 years. So conceivably, the child might have been born somewhere else, might have come to the UK either legally or illegally, with the parents presumably. The child must be either a British citizen or a child with 7 years residence in the UK. So of course this envisages the possibility that the child might have got settled status but less than 7 years residence. If that's the case, it doesn't work. The child must be either a British citizen or must have lived in the UK for 7 years, either since birth or not since birth. That's all the rule says. It's as simple as that. You must have the genuine parental relationship. I'm sure that we all know what a parental relationship is, don't we? It doesn't necessarily mean that you have to live with the child, but if you don't live with the child, nonetheless you must have a close connection with the child, a close relationship with the child. Something like a parent. May not be a biological parent, it could be a stepchild, it could be less than that. It must be a genuine, strong parental relationship. Now, the rule says something soft and easy. If the best interest of the child, they have to be taken into consideration as a primary consideration. That doesn't mean the primary consideration. The best interests of the child are a primary consideration. You know the difference between a and the. It means something slightly different, doesn't it? It's like if you win a gold medal at the Olympics, two people win a gold medal and they both win a gold medal. It's not the primary consideration, it's a primary consideration, and not an overwhelming consideration, but a very strong consideration. Primary consideration could be overruled by other things. It's a primary consideration, it's not the primary consideration. It could be overruled by other things. And, very importantly, it's not reasonable to expect the child to leave the UK. I'll say those things again, very, very important. Your application must be based on the idea, the principle. You have the parental relationship with the child. It's in the child's best interest that you could stay with the child in the UK properly. It's not an overwhelming consideration, but it's a strong consideration. The best interest of the child, not the best interest of you so much. It centres around the best interest of the child. It's a primary consideration. It's weighty. Now, of course, as soon as you think about this, you don't have to think very deep, because there could be all sorts of situations, couldn't there? I remember many years ago, before the family rules came into effect in 2012, before that, there was this 7-year rule. This 7-year rule has existed in UK immigration law for years. It was a strong thing, and historically very strong. You know, if a child had lived in the UK for 7 years, either from birth or from a very young age, that was a very, very strong consideration, because child had lived here for 7 years, child is in their formative years, formative part of their life. 7 years was 7 is always a magic number, isn't it? 7 years, thought the magic number was 7 years. After 7 years, the child had become so attached to living in the UK that it would be very unreasonable or unfair or inappropriate to remove the child. That 7-year principle has existed still, but I would say it's become a lot weakened by case law over the last few years. I'm sure most of you are legal intellectuals. In case you're not, case law are the decisions from the upper tribunal and the higher courts. The case law is binding on the lower courts and binding on the Home Office. Case law from the courts, and indeed from the Home Office's own guidance and policies, says that 7 years is a magic figure. Child has lived in the UK for 7 years. This makes them feel British, if you like. It makes them have absorbed British culture sufficiently that it's not going to be reasonable to throw them out. I have to say that over the past few years, that has been degraded and weakened. It's not quite the same as it was. Also, I'd like to say something else. Of course, there are different types of cases, aren't there? Now, you, the applicant, you might have come here legally on a visa, you might have become an overstayer, you might even be an illegal entrant. The other parent, we don't know, it depends, doesn't it? The other parent might have come here illegally as well. The other parent might not hold leave. In fact, all three parties might not have any immigration status, mother, father, child. As things go, this is a weaker case. However, let's not be too certain about that, but as things go, because every case depends on its own facts, as things go, that's a weaker case, probably. Let's take a different situation. The child's other parent has got leave in the UK. The child's other parent is legally in the UK. Child's other parent may have a different ethnic background from you. You know, child's parent might have been born in England. You might have been born in Venezuela or Pakistan. There may be different language issues and things. A case like that, where the other parent has got lawful immigration leave in the UK, the case looks a bit stronger, probably, because then you get about issues about, well, okay, if the child's going to leave the UK, then the other parent probably is going to have to leave the UK as well, because everybody knows that the best situation for the family is that they're all kept together, isn't it? This is common sense. It's also Article 8 of the European Convention on Human Rights. Families should be kept together where possible, where the law allows. Another situation, my experience, quite common, the other parent in the UK is British. Now, of course, if the other parent in the UK is British, very, very likely, I would have thought in 99% cases, the child is British as well. Because, as I'm sure you legal scholars all know, child is born in the UK with one British parent, the child is British. It doesn't matter about the other parent. In many cases that we come across, the other parent is British, the child is British. Then I think the case is, other things being equal, the case is strong. However, the applicant might have got some bad immigration history, some case law. You hear the judge says, this person has appalling immigration history. You know, it happens, doesn't it? But where the child is British, other things being equal, then it's a strongish case. Now, of course, we do get cases where there's criminality issues. We get cases where there's a deportation order against you. You know, you want to say you can stay in the UK because of FLR FP. Home says, well, we want to deport you anyway. You're a bad person. Every case is different, and I must tell you very strongly, people always ask immigration lawyers, how strong is my case? It depends very much on the facts of the case. Some cases are much stronger than other cases. There's a lot of case law from the higher courts about this. If you get involved in this, your lawyer hopefully will advise you well. I do notice this from the case law, one particular thing. Where the child is a British citizen, it should be the strongest type of case, irrespective of anything else, because this was a case in the Supreme Court many years ago. If you want to be technical, which you might not, but anyway, I'm going to give it to you. A case called ZH Tanzania in the Supreme Court many years ago. Supreme Court says that a British child has got more rights than any other kind of child. It's got more rights than a child who's settled, more rights than a child who has a visa, more rights than a child who has no legal status at all. So the cases are different. If you want to get really good advice on your case, of course, you need to go to a competent lawyer. I do want to say that there's no simple and straightforward answer and solution. You need to get advice about the strength of your case. At GSN Immigration, we always try to do that. Now, if we agree that you're going to go ahead with your application, and don't forget, if the application is refused, there is the right of appeal to the first tier tribunal, which is held in the UK. Immigration lawyers always say, and I think they're right, other things being equal, you get a fairer decision, a fairer consideration from an immigration judge who's a highly trained lawyer than from a Home Office caseworker who may be a good one or a bad one, depends on the weather and everything. You should get, other things being equal, you should get a fairer decision from the tribunal, from an immigration judge, than you would do from a Home Office caseworker. Hopefully it doesn't come to that. Some applications are stronger than others. Hopefully your application will be successful if it's presented in a good way by your immigration lawyer. If you want to go ahead with this, the fee for the application, now in every case this is going to be an in-country application, it won't be an entry-clearance application from outside the UK. The visa application fee is £1,048 today. The IHS Immigration Health Surcharge fee is £1,560 today. However, now is the time to move quickly, because we know that in the next few days or couple of weeks, IHS fees are going to go up sharply by about 60 or 70%. We also know that visa application fees are going to go up as well. So now, if you're going to do it, now is the time. These are what the fees are today, but it's going to change in the very near future. Government puts fees up as much as it likes, really. There's not really any laws to control it. So I'm being honest with you about this. If you make your application and you pay the fees before the fees have changed, then your fee is good. It doesn't matter how long it takes for the application to be considered. Home Office say that it can take 24 weeks to consider such an application. Let me emphasise to you very clearly, this is a case that should be understood, but not always. If you've made your application, your immigration status is secure. It doesn't matter how long it takes the Home Office to make the application, your immigration status is secure. If it takes the Home Office 2 years to make the application, which sometimes happens, your immigration status is protected through all that time. So whatever you have now, you will have all that time whilst the application is being considered. I do apologise for such a long introduction, but I thought it was quite a complex subject. Mr. Shah, I can see by your nervous twitching that you've got some questions you want to ask, but please go ahead.
Thank you very much for elaborating on this topic in detail, because there are so many people in the UK who could benefit from making an application under FLR FP based on their relationship with the child. Now I would like to ask, can a stepfather or a stepmother also make an application under this category if they have some sort of responsibility or involvement in a child's life?
Yeah, if it's real and solid, yes, they can.
Okay, great. And would I be correct in assuming that parent doesn't necessarily have to have a legal status already in the UK? They could have, for example, no status at all.
No, no, you would need advice on that. I can't give you a straight answer to that. If you have a case like that, you'd have to approach a competent lawyer such as us, and you need to get advice on that.
Perfect. And also speaking on the same area, could a non-relative who might be heavily involved in a child's life because of certain circumstances, for example, based on health and medical grounds, could they also make such an application under this category?
Yes, but the application needs to be on the basis of a genuine parental relationship, not an auntie relationship or an uncle relationship. A relationship that is like a parental relationship. I mean, we know what a parental relationship is, don't we, for our normal life? It needs to be solidly like that.
Sure. Could I'll give you a couple of examples to confirm if they would fall into this this area of responsibility. So, for example, if someone is taking the child to the school, picking them up, dropping them, taking them to the doctor, or going to school meetings for them, and could be emergency contact on the GP list, could be,
yeah, all that kind of stuff. But also some financial input is probably going to be, I wouldn't say necessary, but useful.
Perfect, such as doing some shopping for them and stuff like that.
And giving money to the other parent, pay their rent and things like that. Financial involvement is always good, as well as that other kind of stuff. But if you have both, it's the strongest kind of application.
Fantastic. I think you may have mentioned this already, and there is a right to appeal if this visa is refused.
Yes.
And if the first-tier tribunal, they dismiss the appeal, it could be taken up with the upper tribunal.
Well, you're jumping very far ahead, Mr. Shah, but if the first-tier tribunal dismissed the appeal, there's the possibility of further appeal to the upper immigration tribunal, but you have to get permission for that. The upper tribunal, actually, first of all, the first-tier tribunal has to give permission. If they do or they don't, it goes one way or the other. If they don't, then you can appeal directly to the upper tribunal, but eventually you have to get permission to appeal to the upper tribunal. It doesn't just happen by operation of law. Now, if your visa application is refused, by operation of law, you have the right to appeal to the first-tier tribunal. You don't have the right by operation of law to try appeal further to the upper tribunal. You have to get permission. A lot of legal things you need permission. This is one of them. Hopefully we won't get to that, but some cases do.
Yes, great. And in regards to making this application, you mentioned this can only be done within the UK.
Yeah, this is an FLR FP, that further leave to remain. I don't think anyone really knows what FP stands for, but FLR stands for further leave to remain. That means in the UK. You've got leave already. Well, not always actually. You might have leave already, or you might be an overstay, but further leave to remain means you're applying for leave in the UK.
Sure. You mentioned the processing time, about 24 weeks, which is about 6 months.
That's what you told me.
If the Home Office is taking longer than that, which they do in some cases, can the applicant approach their local MP to intervene, although the applicant might not have legal immigration status to reside in that area?
This is a very, very good question, and it came up a few years ago. I used to think that it didn't matter if you were here illegally or not, you could approach your MP. If you're here illegally, you don't have a vote, do you? Some MPs, they don't like illegal immigrants because it upsets their ideas about the proper way to run the country. I would say if you're here illegally, you don't really have an MP, you don't have a right to vote. I would be very, very careful about it. I did see things a few years ago where some MPs were complaining. People who weren't really constituents, they lived in their area but they weren't constituents. And they said, no, these people I can't help these people, they're bad and they should be thrown out of the UK. I would be very, very careful about approaching your MP if you don't have legal status, I'm afraid to say.
Okay, and while this application is in process, the applicant can be fearless that if they are encountered by the enforcement the Home Office, they wouldn't be detained or deported?
Well, I can't say they wouldn't be detained. I mean, who knows? Certainly by the law, they can't be removed. They might be detained in some luxurious prison cell for a few years, police station, but they cannot be removed. It's by the law, they cannot be removed.
Fantastic. Perfect.
Can I add one thing?
Mm-hmm.
Question you asked earlier, I've had time to think about it because it comes so fast and furious.
Mm-hmm.
If the other parent doesn't have immigration leave, I'm fairly sure that the Home Office will contact the applicant or the applicant's lawyers and say, what about the status of the other person? That they're going to ask questions. Now, the law doesn't say anything about that at all whatsoever. The law just says you can apply for this visa, for this leave to remain on the basis of the relationship with the child. It doesn't say anything about the status of the parent, but I'm pretty sure the Home Office is going to write to you, the applicant, or probably more obviously in your case, the lawyer, say, what about the other parent? What are they going to do? Are they going to stay here illegally, or what? So that it wouldn't just end there. Mm-hmm. But I'll say something else. Some of these cases are quite desperate. They reach the higher courts. Both of the parents are here illegally. The child is here illegally. If the facts are strong enough, the applicant can succeed. And following on from that, sometimes applications for other parent can succeed as well. It depends. I mean, this article, we're talking about Article 8 here pretty much. European Convention on Human Rights, Article 8, the right to private and family life. Anything can happen. It depends strongly on the facts of the case.
Fantastic. Thank you so much for today's vlog.
It's a pleasure. It's warming out.
And we see you in the next one.
See you next time.